Good day, my name is Rafi Akram Degama. I'll be presenting the online lecture for Learning Unit 6. The idea is to cover each learning unit for this part separately because I do think these concepts can be tricky, and I will be putting them up as very distinct learning units. Good day. I would like to present to you the online lecture The PowerPoint will focus on Learning Unit 6, that is Insurable Interest. I would like to refer you to the addendum in the study guide for a bird's eye view. You will see that there are various diagrams there for each one of the learning units, gives you an overall view of what the unit covers. Sometimes it's good to start off by looking at that and then moving into very specifics. Each of these learning units go in quite a lot of depth with different things. I will not be going into very specific cases, but I encourage you to study the cases and articles, and you will see that there's a difference between study and read. Study would, I think, essentially mean that you have to read it and summarize it so that you have the essential concepts that are decided in that case. And I will also encourage you very strongly to read the study guide and study the parts that are referenced there, and you'll see the very specific sections that you're referred to. Now, it is vital to keep in mind the background, and I think Professor Jacobs covered this already. What are the requirements for a valid insurance contract? And of course, there was a whole lot of other discussions as well, but it's very important to keep that in mind when we talk about the concepts from Learning Unit 6 onwards, because when we are talking about essentially insurable interest, we are really looking at, as you can see right down the list, the insured must have an interest in the outcome of events. So these are the essentialia that are necessary for a contract to be an insurance contract. And it is necessary that it is there. We'll come to a little bit of a discussion around that because there are some uncertainties, but always refer back to what is required by insurance contract, and then we talk about the various things, and I will get to misrepresentation, I will come to premium, I will come to risk. We are starting today with insurable interest. So the idea is to really understand insurable interest because it could negate the essentiality of the contract and therefore not for it not to be an insurance contract. Now, what is insurable interest? And here, quite widely, already at the onset, we are keeping indemnity insurance and non-indemnity insurance, two very separate things, separated out in our brain. So this, for indemnity, it would be the interest in the object of risk that you have. In the case of in case of liability insurance, it would be the interest in the occurrence of an uncertain event. And I think that's quite important to just keep those two things quite separate. And just remember, when we are talking about insurable interest, it could take more than one form. So I could have, for example, as I've stated, an interest in the car I drive, which is an object of risk. Or I could have an interest in protecting myself against a claim where I cause an accident. So therefore, I'm trying to cover myself if there is a materialization, there is an actual occurrence that happens, an uncertain event, because of course, having a car, driving it, does not necessarily mean that you will definitely be in an accident. There is an uncertainty to it. So that is something just to keep very much at the, understand those two things and understand what the difference is. continuing to discuss insurable interest, you'll see that there is, I think, a very interesting idea of what is insurable interest and how important it is. The main idea is that an insurable interest specifically is a way of differentiating between an insurance contract and other contracts. And I use here the example of a wager. Apologies for that, I should have said it's the differentiation between an insurance contract and other contracts like a wager. In case of a wager, of course, it's an uncertain event. You don't know if you will win or lose, but there is an actual interest in the object of it, or you do not have a personal interest in the actual occurrence. So that is really one of the earlier ways that we realized how important insurable interest was in insurance contract. It was a way of really setting the insurance contract apart. So it is seen, therefore, to be a distinguishing feature of an insurance contract, and that is how English law really sees it. In South African law, even though we adopted the concept from English law, our position is not as clear and less certain. So we have two very different views on this in our law. Of course, remember there's a history behind it, and I know in your textbook there's some discussion of it. We obtained concepts and so forth from English law, and then there was a bit of a clearing out of those and then going back to our roots, Roman Dutch law roots. I'll come back to that specific instance as well in one of the cases we'll discuss under misrepresentation. And I think that would be a fascinating thing just to refer back here as well. So what are the two diverging views? Firstly, that actually insurable interest is not required to exist at the onset of liability insurance. So therefore, it can't be a distinguishing feature. So when it is liability insurance, you don't require for that to already exist. It can, if you are only waiting to see if it happens later on. And also, and for that reason, does it then serve as a requirement for validity or enforceability? I mean, those contracts are still enforceable. So theoretically, there's been a lot of discussion amongst authors and so forth, and even when it comes to the link between indemnity and insurable interest, they're seen as two sides of the same coin, that if you have an insurable interest, it's linked to indemnity, what you will get, what you are indemnified at. But of course, we do look at loss and damages and as ascertainable without reference to the role of interest. So that is another thing that, even though it's connected, it's not seen as an essential way of calculating things. So, and of course, in case of non-indemnity insurance, of course, you only require it, and when it is acquired is also similarly sort of impacted. So what is the other? It's that in our courts, however, we have seen decisions over the years in the past where really insurable interest was accepted as an essentialia. This also meant that in practice, the practitioners in insurance field then of course followed that same thing. So we have the theoretical issues around it and criticism of it that has happened, and very logical criticism really. And our courts have, up to this point, really held on to insurable interest as an essentialia. But recent case decisions show signs that is being questioned. And I would here really refer you back to the prescribed court cases to read quite closely. So it's very important here, I think, before you go off and read all the court cases, just to know some of the terminology that you will encounter, And I'm going to just do that by way of an example from your study guide. It was an excellent example that is there. We say, you know, oh, A insures his or her house. In truth, what they're actually insuring is their interest in their house. So yes, they are the owner and they have a specific interest because they are the owner, but it is really that they're insuring not the house itself, but their interest. So if something happens to the house, they can make a claim so they can replace it or fix it or whatever it is that they need to do. So their interest is the object of the insurance, not the house. The house, in fact, is the object of risk. So I think that is just something to keep in mind, these two, sort of this idea of object of risk versus object of insurance. And of course, insurable interest. So these three things, just keep them very clear in your mind as you read the cases. I'm going to look at indemnity and non-indemnity insurance as two very separate things so that we can keep those two things separate, because the nature of the interest required and time when interest is required is very different for both of them. So the nature of interest required in indemnity insurance is of a financial nature. So the insurable interest is to make good any loss suffered. I'm going to just refer you to those paragraphs in Ranneker that you should read, 3.17 to 3.64. The time when that interest is required, it is at the time of loss, not when you conclude the contract. And that is quite interesting. So you could have a contract, you know, having bought a house but not yet sort of moved in and so forth, and that would be perfectly fine. And if once, even if you don't move in and something happened to it, you will be covered, because of course, you know, there is that interest that is with you as an owner. So that means that future and ascertainable interest may be insured. So just remember that as long as it's if it's in the future, as long as it's ascertainable that it may be insured. So indemnity, the examples of indemnity, for example, you know, owners of an object would have an interest. So when I say the object of risk, for example, would be a car, a house, you'd have the interest, your interest in the house would be your insurable interest. However, you don't necessarily need to be the owner to have indemnity insurance. You could be renting. You could, and that would create a link between yourself and the object. Because of course, if something was to happen to it, you might have some sort of, you would suffer some losses. So just remember that, you know, it's not just for owners, please. Of course, we'll get to that, and then I think there are a couple of cases where there is a case where you have people who are in a business together. There's somebody, one of the people or the business owns the object, and something happens to the object. Do the shareholders in the business then have an interest? And please read the case. The other case, I'm giving you the facts so that you have to go and read all of them, is where a husband insured his wife's jewelry. And does that husband have an interest in their spouse's jewelry? That's something to think about. And then please, again, go read the cases. When it comes to non-indemnity insurance, this is quite an interesting thing, because the insurable interest here has not yet been determined. And that is because non-indemnity insurance itself as a concept is quite shrouded in mystery. And I think there are ways of looking at it. And the first is that it is exactly like indemnity insurance, and it should not differ. And therefore, the insurable interest should be the same. the other one is that one cannot truly equate indemnity insurance and non-indemnity insurance. I mean, here we're talking about my interest in my own life. I can insure my own life. So that is very different as a concept than insuring something sort of like a car. So just remember, there's quite a lengthy discussion in your study guide as well as in your textbook. So please go and read those. I think it's fascinating, and this mystery itself is going to be, I think, it'll come to a head at some point. So the other interesting factor is that, if I wanted to insure my own life, I should be allowed to insure it for any amount, because of course I have an unlimited interest in my own life and in preserving it. Now, this cannot be true logically for the life of another, and is certainly not true for children. There are in fact statutory limitations in terms of to what extent you can insure a child's life. There are also discussions, of course, on whether the term spouse includes those who are married under customary law, and so forth. And there are a lot of questions of how you connect another person's life to your interest in that life. And of course, when we talk about that, we talk not just about our immediate family, we talk about our broader family. We have in South Africa, and I'm sure you learned during the law of succession as well as in family law, that there's a legal duty of support that exists, and that sort of exists in a wider concept of family, from grandparents to uncles and aunts. There's this idea that you would support, you have a legal duty to support. So insurable interest could be linked to that duty of support. Or should we really require some other form of financial interest? And it's something to ponder and to see theoretically what is the basis of it, and so forth. But just remember that one's own interest in one's own life is unlimited, but that is not the case in the life of the other. And it's especially not true when it comes to children. Now, when do you need that interest to exist? And that for non-indemnity insurance is when the contract is concluded. So that means that the insurable interest here is an essential feature for that contract to be one of insurance. So now, if the validity of that insurable interest, for example, falls away, people get divorced, and so forth, that will have no bearing on indemnity. And that brings us to sort of this idea. I wanted to give you guys a few examples to think of. So A will have unlimited interest in his own life, for example. So now A insures his wife's life, and they are subsequently divorced. So if he continues to pay the premiums, he can still claim the sum whenever she dies. So he will still be able to claim. So even though they no longer have that duty of support, that link between them anymore, the contract is valid because it has to exist at the time of insurance. In the case of insurance of a third person, there is some interest, some financial interest that is required. And here again, I refer you to Renneker and et al. 3.14 and 3.170 to please go and study that.